We will go ahead and get started with our little webinar from today, and we will be recording this. It'll be on our YouTube channel and Facebook, so feel free to share with anybody you want. My name is Lauren Ward, and I'm an attorney with a business law firm here in Spartanburg, South Carolina. And today we're just going to do a quick webinar. I don't have slides, just kind of want to talk to everybody about tips for making sure your will isn't contested when you're no longer here. I think the point of doing a will is so you can have control of your assets. So you want to make sure we do everything possible so it's not contested, or if it is contested, it really holds up in court. Recently, we have been seeing a lot more will contests. We've kind of been a little bit heavier on the litigation side with those will contests, which is really kind of sad that the person's family is fighting over this estate, and what do we need to do to stop that? Because most of the time we don't want our families to fall apart when we're not here anymore. So today we're just going to go over some quick tips to help you or your clients or friends and family make sure we don't get those wills contested if possible. So in South Carolina, the requirements for a valid will are pretty simple. The mental capacity is you have to know what you have and who you want to give it to. Very low bar for that. Now, on the other side, if you're signing a power of attorney, so this is for somebody to handle your finances while you're living and incapacitated, it's a contractual of capacity. So you actually have to understand the document you're signing and the ramifications for it. So wills have a pretty low standard for mental capacity, but those powers of attorney have a higher bar. And then what else a will requires in South Carolina is 2 witnesses, and those witnesses need to be disinterested parties. So that's pretty much all that's required to have a valid will. So why are wills getting contested? One of the main reasons I see is the mental capacity issue. You don't want to wait until you've been diagnosed with dementia or Alzheimer's or been in an accident or you've undergone surgery and you're recovering from that to do your will. This is where we see the most issues, is somebody maybe was already diagnosed with Alzheimer's and did this will, or somebody has had really bad dementia, or they're 95 years old. So the family's questioning the capacity, especially when we see at that point one family member, getting everything and the rest of them being written out of it. So one of the biggest things is making sure you do your will while you still have no issues with mental capacity. And while none of us know what tomorrow holds or guarantee tomorrow, the sooner the better in the will world. And this is what happens to a lot of people. They can't decide what they want to do. So they keep putting it off, and then it's too late. So they don't get to decide anymore. The Uniform Probate Code does under the laws of intestacy. So while it's hard to make a decision, it's better to make that decision while you are mentally competent to do so. A lot of times when we've been seeing will contests, it's due to possibly this mental, not knowing if they had mental capacity, plus some undue influence or elder abuse. So we've seen this a lot too, when parent all of a sudden decides to change their will from leaving everything to, their 3 kids all to 1 kid, and the 1 kid they're leaving it to has kind of ostracized the other children. And mom doesn't get to talk to them anymore, kind of push them out of the picture. And this one child's getting everything, and then parent dies, and the sibling comes and is like, I was supposed to inherit, a third of mom's estate. And we realize, oh, mom updated her will, in 2022 when mom had already been diagnosed with Alzheimer's. And at that point, a lot of times what we're doing when we're looking at these elder abuse and mental contest situations, we're going to have to pull the person's medical records. And this does get costly for your family because subpoena and medical records can be expensive. But what we do is we go through them, and we're going to make charts to figure out, when did this person first get diagnosed with Alzheimer's, dementia, or have a stroke, or whatever else incapacity, and look at that timeline. And we'll also look at the timeline other things happen, like When did they have the POA for this other child? When did all these assets start moving around? And then we're going to see there was probably definitely some undue influence, and mom or dad didn't have capacity. So one of the biggest things you can do to protect your family is get this done while you have mental capacity. And it's okay if you want to write out, some of your children or grandchildren. If you are perfectly mentally competent to do so, 100% okay. But you need to do it while you have that capacity to do so. These will contests are very hard cases. It's hard on the family. And that's the biggest issue we typically see, is the fact that you just didn't have capacity to do it possibly, and we're going to a will contest because of that. Another issue we see a lot of times is not having the formalities. So this is two witnesses. But say one of those witnesses was your spouse who you're leaving everything to. Well, that doesn't count. So in that situation, your will doesn't comply with the formalities. So that's why it's important to see an attorney to make sure you have the two disinterested witnesses, so there's no issues with the formality, because the will could say everything you want it to, but if it's not witnessed properly, the probate court is not going to uphold it. So making sure it meets those formalities, making sure that all the pages are there, they're all the original pages, and it has those formalities. So a lot of times what we see people do is initial the bottom of every page, so that way you see that it's the original pages. So those two witnesses for the formality. Those are some big reasons. And then some other reasons that we've seen wills contested is the wills doesn't have all the elements in it that we need to have there. So for instance, the will says, I give my house to my oldest child, Bob, and that's it. The will doesn't list who the residue goes to. So who are the bank accounts going to? Who is everything else going to? All it lists is a specific bequest of the house to Bob. And in those situations, if the will doesn't have a residue clause, it's going to go through the laws of intestacy at that point. So that's what the Uniform Probate Code would say, which is half to spouse, half to kids, or if you're the surviving spouse, all split between your kids. So when you don't have all those assets listed or have that residue clause, a lot of times a will contest is going to come into play, because the person will say, well, my mom's intent was to leave everything to me, but she didn't specify that. And a lot of times we'll see this on those homemade wills that somebody just typed out and signed, and doesn't have the formalities it needs to, so that all your assets are truly taken care of through this will. Those are usually our biggest issues we see, but there are some smaller things here and there we'll see. A lot of times people will do a will but not give their personal representative authority to sell property. And while this doesn't lead to a will contest, this could lead to more frustrations for your PR, because say your house has a mortgage on it and your family needs to sell it because nobody wants to pay your mortgage payments, and your will doesn't give that authority to sell, then you have to file a petition with the probate court in order to have that ability to sell. So that's one thing that, while it doesn't lead to a will contest, it does probably frustrate your intent of letting your PR handle everything and deal with your estate as efficiently and quickly as possible. But really coming back to it, the whole thing is to make sure that your estate is given out how you want it. You really need to do it in time. So you need to do it while you're mentally competent. Don't keep putting it off. Don't wait till you're 90 years old to come do your will. And some people are completely mentally competent at 90 years old, but usually is when that kind of comes up and you pull your medical records for a 90-year-old, a lot of times you are going to see forgets things. Like for instance, one case, there was the issue of, did this person have dementia or not? They weren't formally diagnosed with it, but it was, this person doesn't know how to get around the grocery store, they get lost coming home, and those type things. So maybe there's not even a diagnosis of dementia, but there's enough there to show that this person didn't have capacity to do so. So in those situations, having it done ahead of time is the biggest thing I can stress. And not just for your will, but your powers of attorney. As I mentioned earlier, that's a higher bar for capacity. And with that higher bar means you really have to be fully mentally competent to execute that power of attorney. If not, you are putting your family in jeopardy of having that power of attorney objected to or litigated in court, and then having issues where your family's going to fight afterwards. And if you don't have a power of attorney done while you're mentally competent to do so, your family has to go through what's known as a guardianship and conservatorship proceeding, which is very costly, expensive, time consuming. It is not worth you going through when you could very easily go get that power of attorney. Usually a power of attorney is not that expensive, where a conservatorship is expensive. And there's also, when you get appointed a conservator, most judges are going to require you to pay a bond. And what this bond is an insurance policy that shows if you absconded with the money, there's this insurance policy to cover it for this incapacitated person. And that bond is based on the size of the estate. So say there's a pretty big estate out there that you're handling as power of attorney. Well, you didn't get the power of attorney. This person has $1 million in assets, even if their assets controlled in retirement accounts, IRAs, all that type of stuff. The court still wants to know the total value of it, and they'll base your bond off of it. So $1 million is going to cost you probably $3,000 or $4,000 in a bond. If you would have just done that power of attorney when you were mentally competent to do so, your family wouldn't have had to go through the conservatorship. And if you did the power of attorney when you weren't mentally competent and they have to overturn it, you're going to have to pay the cost of litigation, the conservatorship fees. So it's very expensive. So the best thing I can tell everyone to do is don't keep putting this off. That's when it's going to be contested the most. Almost every will contest I've seen has to do with capacity, because it is mom was 90 years old and changed her will and left everything to one child and wrote out all the other children. And it's fine to do that as long as you have mental capacity. But it usually doesn't come up when mom did this at 55 years old and we knew mom was completely competent to do so, or even 75. But once you start having those diagnoses of dementia and Alzheimer's, putting a new will together is very likely to be contested. So say you do have that diagnosis of dementia, but you're in the very early stages of it. One thing you can do that can help prevent the will from being contested, have a doctor write you a note within that time frame that is a medical opinion that says, John Doe has mental capacity. While he is diagnosed with dementia, it is very early stages, so he still has capacity to execute that will. And give that to your attorney and put it with your will. So that way, if the will is contested, there is good evidence that at that time you had capacity, because your doctor knows this. While me as an attorney, I'm going to ask you some questions to try to determine your capacity. I'll ask you things like, who's the president? What did you have for lunch today? Can you look at the clock and tell me the time? I'm going to do my best to try to determine your capacity, but I'm not a doctor. Having that doctor's note is one of the best things you can put in your file. If you are at that point where I'm a little forgetful, or I am 90 years old. And honestly, if I question your capacity, I'm going to ask you to get that anyways, because I don't ever want to do a will for somebody who shouldn't have one done because they're not competent to do so. So having that note is just a backup for all of us to protect everybody. So kind of as an overall, what we've talked about, mental capacity and formalities, making sure it is properly done and has all the proper elements of it. So sometimes those wills you get, when you walk to the FedEx store and they have a will template, or you go on Rocket Lawyer or whatever those free sites are, the really cheap sites. While I get being economical and efficient, sometimes those are the ones that are going to be contested the most, because we want to make sure it complies with South Carolina law and has everything in it. And one other thing about going to an attorney to get your will done, there's a witness that says your will was valid and properly done, because you're probably gonna have to subpoena them into court and everything. So that's kind of, just wanted this to be a quick, short webinar on the things we've been seeing with will contests, and making sure it's important to do this while you have capacity and that you do it properly. And that saves your family a lot of heartache, a lot of stress, because in the future, the last thing you want is to leave your family fighting, because I've seen families torn apart, families that were close, torn apart, and making sure you see an attorney early enough. And especially if you're a blended family, second marriages where there's different children involved, make sure you get it done properly while you have mental capacity, because there's probably already some tensions there most of the time. And when you deal with finances, it just explodes and makes things worse. So make sure you get it done while you have capacity with the proper requirements. Does anybody have any questions? Yes, Sonia.
Hi, Lauren. Thank you so much for doing this. We appreciate it. So my question is, as long as that letter is done from the medical person, from the medical physician, even though they have dementia, then the will not can stand in court, I guess, even if
So
someone
I
contests it.
can't, yeah, so I can't promise nobody's going to contest it, because people always do that. But with the bar being kind of low for like mental capacity for a will, you just have to know what your stuff is and who you want to give it to. So it's really, do I know the objects of my affection is like the rule, and who I want to give it to. So it's really a low bar. So if you get that doctor's note, and with dementia and Alzheimer's having such a broad range, if a doctor is pretty confident in saying, yeah, they may have dementia, but they still know, like, it's very early stages, that's, I think, good, just evidence on its face at that time that you had capacity. Because the hard part is, after you passed away, we're going to just have to rely on the medical records and like doctors reviewing it and everything. And that's hard or to quantify like what your mental state was at the time. I've even had, I went to a CLE this past summer, and they kind of talked about, or it might have been 2 summers ago, having like even a medical expert. If you really, most of my clients aren't this wealthy to where, there's billions of dollars here, but having like the medical expert sign it while they are at, or have the medical expert come and do like an affidavit or testimony the day you sign the will in the office, if you're really worried about contesting it. Especially if you're doing something that your family is probably not gonna like say, if you do a will and you leave it all to your 3 kids equally, nobody's probably going to contest that, because that's what most people would do anyways. But say, you really have a bad relationship with your kids, they haven't came and checked on you in years, you don't like them anymore, kind of situation, and you want to leave it all to your church or a nonprofit, because those are the people that have helped you out. That's when I really, really, really stress having that doctor's note, because your kids are probably going to contest it.
Okay, thank you.
Any other questions from anybody? Well, we will wrap this up then, and you are always welcome to give me a call or an email. My phone number is 864-699-9801. My email is LEW, my initials, at abizlaw.com. So LEW at abizlaw.com. And once again, I'm Lauren Ward with A Business Law Firm in Spartanburg. And thank you for joining us today. And please feel free to share this, and don't hesitate to reach out if you have any questions. Thank you all.